also gotten some play, as I mentioned earlier, about some of the other domestic war crimes courts that are emerging in other countries. The argument that actually for domestic courts to coming out of post-conflict environments, that it's really a significant risk to undertake these types of trials without significant international support and involvement through a hybrid nature type system. And so on that point, I wanted to ask whether or not your views on this hybrid nature she's asking.
Mark, I may say something on Kosovo on this one, too.
I'm sorry?
On Kosovo.
On Kosovo? Was that on Kosovo? On there? Kosovo as well.
Well, Stephanie directed one of the questions to me. I think the other one as well. But and I'm not sure you can really call Bosnia-Herzegovina's war crimes effort a true hybrid effort. It's not. It's a domestic court. It applies domestic law. International laws become part of domestic law in the criminal code. The criminal procedure code is the criminal code of Bosnia-Herzegovina. What there is there, or has been there up until the end of the year, was an aggressive involvement of international prosecutors and judges in the application of domestic law. Whether there's an organic transfer of skills or not, I think that was a bit of conceit on the part of the international community when this whole system was set up, that because people in the local courts and prosecutors' offices didn't know enough to handle this on their own, they had to have international people there to show them the way. I don't think that's true at all. I think what happens is by being together and working together, there are certain things that are learned by both sides. But I think the primary objective of having international prosecutors and judges working in the court in Bosnia-Herzegovina right now is just to get the job done, get the work done, do as much as humanly possible to get as many of these cases in the most organized way possible, finished in the shortest amount of time, and still preserve the defendants and the victims' rights. That's the objective. And so if it takes putting internationals in there to do that, so be it. If you're looking for an education benefit, maybe it'll come, maybe it won't, but that can't be the primary objective of having people working there. As far as the other question is concerned, I understand numbers. Numbers are a big deal, but numbers don't mean much at all. If you're talking about the kinds of things that are done at different levels, and Amor's here, and Zadravko, and Zakaria, and I respect them immensely in terms of their responsibilities on the local level for doing daily crime and everything else that's thrown onto them at the same time. I think some of the effort to get the cantonal prosecutors and district prosecutors involved in doing war crimes at a large level was misguided, but that's a personal view based on experience. I think it would have been better if it had all been concentrated in the state, and I think Madam Cresso and others in the beginning believed that as well, and I think it was an effort that was well placed to try and make that happen. To get the development of the law more consistent, its application more consistent, you need to have that centralized. But Stephanie's right. That question, that train has left the station. That question is no longer one to be decided. It's been decided politically by the strategy. So we have to work out ways of making that work better. And there are ways that we have tried to do that with Practice Direction 5 and prioritization criteria and that sort of thing. And that is a function of the international side being involved to try and help develop that. So it's a complicated situation. It can't be easily answered by numbers. Yes, now that the political decision has been made, prosecutors at the cantonal and district level need to have better support, not education and training, better support. They have to have the money, they have to have the witness protection ability, which they don't have at the local level. They have to have any number of things that come from a centralized, but it's not centralized anymore. So you've got to duplicate all kinds of things in a country that can barely do what it's supposed to do at that level.
Thank you.
Let me just add very quickly that UNDP has identified that lack of capacity, especially in cantonal and district courts, primary courts of Republika Srpska. We do have a program that has to address that issue, as David said. I mean, we are in a situation where and I think it's a dire need to actually address that because there's very little been done. So UNDP does work on this and has helped put the strategy for it.
Shelley, if you take that the question into Kosovo, what was your
Yeah,
reason?
I mean, I just wanted to say, and you asked me at the beginning to speak about Kosovo, and I sort of went around it, but on the organic transfer, I think there's a lot of question about whether that really happens. I think there is, a lot of people have said that at least in the Kosovo experience, putting international judges and prosecutors in with nationals hasn't automatically meant an empowerment of nationals or a transfer, meaningful transfer of knowledge amongst both the nationals and the internationals, because it should be an exchange of, obviously, transfer of knowledge, as has been mentioned on the panel. So I think it's a very big question as to whether that does take place, and what is the purpose of putting internationals in national courts. I think that's very much the question. Is the purpose capacity building? And that hasn't been often the purpose. I think it should be. I think the starting point should be capacity building, not the ending point that we get to many years later. But that's just my personal opinion. But I think you will see that evaluations of what has happened over the past 17 years in terms of putting nationals and internationals together has not automatically meant empowerment or greater knowledge on the part of the nationals.
Great. Barbara?
There was a big decision that had to be made in Bosnia about whether or not the international judges and prosecutors would stay on beyond their mandate of December 14th of last year. And in order to make that determination, the Swedish embassy did a study, and it was headed by David Tolbert. And one of the issues that he addressed was the transfer of skills and knowledge from the internationals to the nationals as one of the things to consider about whether or not they should stay. And Mr. Tolbert found in his study that, in fact, there was not very much transfer of skills and knowledge.
Thank you. Okay, back to the audience on questions. Yes, ma'am. You in the brown.
Sorry. Thank you. I have a comment and a question, especially to Judges Pokar and Moloto. My comment is this. Among the sections within the ICTY where least integration of staff originally from the region has occurred is certainly chambers. We have now, for more than a year, a program of internship, which allows young jurists from the region to come and spend some time with the ICTY in chambers, and that's certainly, from our side, beneficial, and I hope from their side as well. Having listened to answers to the first question, I was wondering whether you would consider that time is ripe now for trying to offer to judges from the region a possibility of having this kind of a exchange that I understand is taking place at the OTP level by spending some time, a week, 2 weeks, in chambers. I'm not suggesting that everything we do in chambers is something that should be transposed. I mean, we have heard about the figures, and probably one can wonder whether efficiency is not also to be found in the way the local judiciary is dealing with these cases. But there are a few techniques that we have developed which probably can be of great use, especially for cantonal and district courts. I'm thinking about evidence management at trial, especially in a system where you do not have transcript of testimony. I'm thinking of certain techniques that we use on appeal, and I was just wondering whether you think this possibility is acceptable for chambers in the ICTY, and whether this could be explored. Thank you.
Sorry, Catherine, are you talking of, when you say exchange in chambers, are you suggesting that judges come into chambers? Judges from the region come and work with us in chambers?
To spend some time with a trial team and appeal team, judges and staff.
I really am not able to answer that question. I would imagine that that is a question to be directed to the domestic judges to say whether they think they would benefit from this. I'm not quite sure how one would work with them unless they would sit with us on the bench, and even if just to observe, because there isn't much that I think takes place in chambers other than really going into court. Well, certain things do take place in offices, but I'm not quite sure whether there would be much of a transfer of skills or exchange of knowledge just by being in the office with another judge. But it's a very difficult one.
Judge Pokar?
Well, I agree this is a difficult question. It's quite different from integrating other people in the staff of the prosecutor's office, because it's quite different, the process, the functions, of the prosecutor is a party, so can more easily, as it would be easy to integrate them into the defense, as they are indeed. But one could perhaps consider the idea of participation, if not full participation to benches, but a limited participation to benches, as we have sometimes for our cases when we have the so-called reserve judges that participate, but to a certain extent. It would be slightly different, of course, because there would not be a full participation to decisions, but still it may be more helpful that having judges from the region coming and looking at the hearings, the other side of the glasses. It would be quite of the window. Would be probably, but it's something that could be explored. But I'm not sure it can be done completely.
Thank you. Coming right here.
Thank you very much. I'm Ivan Šimonović. I'm Minister of Justice of Croatia, but I'm also a law school professor. And I do have a question for panelists. Would have transfer of knowledge and capacity building have been much easier if substantive and procedural law of the tribunal resembled more to the local legal tradition of continental law? It has been an ad hoc tribunal, and it could have been tailor-made. Did it have an influence on impact of ICTY on society and on transfer of knowledge and capacity building? Thank you.
Thank you. Who would like to tackle that? Judge Pokar.
Well, let me first say that one of the challenges when establishing the ICTY was to decide on the procedure to be followed. And I believe, I'm sure, the judges who at the beginning had to draft the rules of procedure and evidence, because the Security Council was not able to do that and recognized it was not appropriate for the Security Council to do that. When they did this exercise, they had in mind, essentially, I believe, to find a procedure that would be appropriate and viable for international prosecutions. That's probably, and there could be, as the case may be, exported to other tribunals, international tribunals, as it was, because the ICTR took up the same procedure, the Special Court for Sierra Leone took up the same procedure from the ICTR, indirectly, but it's the same kind of procedure. And to a certain extent, even the ICC takes up certain features